everyone, it's Liz from the Barletta team at Ligris, and I'm here again with Annalie and Ricky from Best of Boston Living with Century 21. So good to see you guys. I'm excited to talk about this next topic.
Absolutely, yeah. Well, we try to find out a little bit of what's the options or ways to take title in Massachusetts. That's where we work. So if you can
Yeah.
probably tell us what's a few ways to do that, and if you can explain the difference on how it being taken and what kind of recommendation for each situation probably will
Okay.
work for our clients.
Sure. So
Yeah, I believe
there's
so.
perfect. So there's three ways to take title for individuals in Massachusetts. The first is a joint tenancy. So this is where, well, I should say four. One, individually. So if it's just you, you're buying, you're individually, right?
Solo ownership.
Two, joint tenancy. So this is presuming there's two people or more, but multiple people you could take as joint tenants with rights of survivorship. That's the language. What that means is in the event that one person were to pass away, the property automatic at the time of your death transfers your interest to the survivors. So if the three of us own property, I pass, my interest automatically transfers at the time of my death to the both of you. Joint tenants with rights of survivorship. The third way, I should say, is tenants in common. Tenancy in common is where the interest, rather than passing automatically to the survivors, it transfers at the time of death to that person who passed, the heirs of that person. So again, with our example, the three of us own property as tenants in common. I pass away. You both don't get my interest automatically. My interest passes to my heirs. How do we establish who my heirs are? Probate. So that the fact that it's not automatic at the time of death and the fact that that has to go through a probate process tends to be, unless it's not absolutely necessary, but considering your situation as a whole, that's why some people shy away from the tenancy in common, because there's this added step of probate. The final way to take title in Massachusetts is tenancy by the entirety, and that presumes a married couple. So if you are a married couple, then you can take title as tenants by the entirety. And in the event that one person passes away, the title will transfer automatically to the survivor. So like joint tenancy, but there's an added protection against creditors where if you are married, and let's say I have credit card debt, if it's property held by tenancy by the entirety, my individual credit card debt can't be a lien on our property because it's a jointly owned property. Jointly owned debt can be, not individual debt, if that makes sense. So those are the typical ways: individually, joint tenant, tenant in common, and tenants by the entirety.
I hear one before that I don't think you mentioned it is the trust ownership. Is that passing
Right.
to
So
a trust?
I was talking about sort of individual people. So people versus entities. So
Okay.
entities can take title as well. Trusts can take title, LLCs can take title, corporations can take title. But in terms of focusing on individual people, those are the ways that you can take title.
Okay. All right.
Now, what if
Awesome.
somebody has a written will? Will
Mhm.
the will override the way that a title is held, or vice versa?
So if you have a will, so it depends on how you own the title. So if you are tenants by the tenants by the entirety or joint tenants, so they have that
Yeah.
same aspect of survivorship, right? It doesn't matter if I write in my will that I want my property transferred to, my son or daughter. It doesn't matter because I took title as a tenant, joint tenant, or a tenancy by the entirety. So my property interests for that property that's held in that capacity will automatically transfer to the survivor, regardless of what I put on paper, separately.
Okay.
So
And now, what if you are not married? Is there one versus the other that's better for a non-married couple? or
I get this
to
question
make-
a lot because I have a
Okay.
lot of clients, first time home buyers, they're, dating their, boyfriend or girlfriend. Their anticipation maybe is to get married, or that's what their future they believe will look like. And they don't have kids. So I think the difference is if it's a relationship that's non-married with kids versus without kids. I feel like that's definitely one of those things that impact greatly the decision to go one way or the other. So if you are, I never want to make a decision for anybody. What I typically do see is if you have a couple, they're like engaged but not married yet, their intention is to, share their wealth and everything together, first marriage, or all those things. I tend to see a joint tenancy because in their minds, they're already husband and wife. So that is the better choice for them.
Okay.
And also that fact that you don't have to go through probate. I do see a lot of second marriages or marriages, or not marriages, but relationships that are, post children relationships. So people are coming with children, or one person in the couple has kids, the other one doesn't.
Yeah.
I do see those relationships tend to generally do tenancy in common. Again, with that type of tenancy, the property will transfer to the deceased heirs. So again, if you have a relationship, your boyfriend and girlfriend with someone, I have, I'm that person, let's say, for example, I have kids outside of that relationship, I would want to make sure that I have a tenancy in common. So, the wealth that this couple brings together, will eventually go to my offspring versus, the other person who's an adult, if that makes sense. So I definitely see that is sort of generally the distinguishing factor. Some clients come and they are, engaged or not engaged, but that's their assumption. But maybe they have, a trust fund, or if they have just parental guidance that feels that it's, you're putting, or they're not putting all equal amounts of money. Maybe they're buying the property together because they're eventually going to hopefully get married. They're not engaged yet. One person's putting all the down payment. Well, maybe I don't, in that situation, I don't want to have an automatic transfer to the person who didn't pay anything to buy the house, So every situation is very distinct, but I think the general, like if you took a poll of clients, most people without kids are going joint tenants if their intention is to get married. Most people with kids from other relationships are probably going tenancy in common, or
What do you, yeah.
siblings or family
I was gonna
members.
say, what do you see when it is like family members?
Yeah.
Like two brothers, or a brother and sister, a mother and a daughter,
Yeah.
any
So with
type of
those,
a family relationship that buys properties together.
yeah. So those situations are interesting too, because usually it all has to do with kids. Honestly, that's what I usually see is like, if family members have children, well, then they generally want it to be a tenancy in common because they want their interest in the property to be protected for their kids. Some people are, adults without children and their siblings, or maybe they're buying with their mom or their dad, older in life. They didn't have kids. In those situations, I do see joint tenancy because the likelihood is the parent's going to pass first and they want to avoid probate for their kid.
Yep.
And so it will automatically transfer to their child, adult child, but that would be easier for estate planning purposes in that respect without having to go to probate.
Let me
So
ask you, go ahead.
no,
Let
that
me
was
ask you,
it.
let me ask you a question here. Is that a possibility? Say, for example, can you change the status or the way you take title after you purchase a property? Is that can be done or it's
Yes.
not? So
Yes.
okay,
So
can reverse or can change any way
yeah.
you prefer?
So the only thing is that there's certain little like little things that you have to do. For example, in order to change it from like joint tenants to tenancy by the entirety, again, that has both the survivorship. The only thing is that added creditor protection. In that situation, in order to transfer to a tenancy by the entirety, like change it, you can't just say, me and my husband transferring as joint tenants and then transferring to that doesn't work. You have to transfer to a third party, and that third party has to transfer it back to you. It's a legal fiction that has to take place in order to have these certain requirements met to be able to take title as a tenant by the entirety. So I think that in some situations where I'm dealing with a, engaged couple, and then they're like, oh, when we get married, should we change it? Do I need to change my name? Because I'm going to probably be taking my, his name or whatever. So you don't have to. Again, especially if you don't have people that you necessarily trust to transfer the title to and then transfer back from, you don't have to. You can keep your property as joint tenants. Obviously you don't have the protection of the creditor part, but you have the same, survivorship protection, and then you don't have to pay for the deeds to be recorded to change it. And in the event that you sell the property later, once your name has changed, all you would have to do is sign the new deeds to your buyers as, my maiden name's Perez, my married name's Barletta. I bought as a Perez, I would say Elizabeth Barletta, formerly known as Elizabeth Perez. So that's all you need to do. You don't have to change the deed just because there's a name change or but if you want to, you certainly can. And the same goes to if you buy a property and then you want to put it in a trust, you can do that. Yeah.
Another question I have is, what do you see as most common for, let's say that there is an individual that gets gifted money to buy a property from a family member? How do you see those people? Do you see often that that individual is the only one that takes title, or do you see that the family member that gifted the money will take the title? And what would be your suggestion?
So, I mean, so it depends too. So, a gift inherently means you don't pay it back, right? So a lot of people use the term gift, but in reality, it's not a gift, but I want some money back later. In the event that, so if you're financing and you're getting a gift, that person, that donor of the money, has to sign a letter that says this is a gift. Like, we are not intending to receive this money back. They're signing that. Some people still intend on getting money back. If your intention is to get money back, then you shouldn't sign that letter. And you should try and have some kind of promissory note or mortgage signed and recorded to protect that. A lot of families don't do that type of thing because it's so formalized. But I do have clients who, lend money or have people lend them money to buy investment properties. Let's say they're not family, so that like weirdness of protecting themselves isn't there. And so I have those situations where someone's buying money, they're borrowing money from someone else. They use that money to buy the property. That person who lent them the money, it's not a gift, it's a loan. And so they would sign what's a promissory note, which is a promise to repay. And then they would also sign a mortgage. And that is the document that protects them from being stiffed by the person who got the money, right? So when you have a mortgage on record, if someone's then trying to sell that property and not pay you, well, they won't get to closing because there's a mortgage on record that has to be paid off in order to deliver clear marketable title. So if you are lending money to anybody, my suggestion is to have a promissory note signed and a mortgage signed, and get that mortgage recorded ASAP.
Been there, done that. So
yes.
Yeah.
I was thinking of you. I wasn't going to say it.
Yeah, you helped me out with that one. So
Well, this was great. This is great information. Thank you for sharing all this with us. Because we do know that we do come across these type of questions often from clients. Ricky, do you have any last questions?
I think that will cover pretty much everything we have, for now. I know it's very extensive topic, but I think that's pretty well explained from you. So appreciate it.
Yeah.
Well, So good to see you guys again. And for all those viewers, if you have any questions, anything specific you'd like to see on these videos, please message us so we can bring you the content that you're looking for. Thank you guys so much
Thank
for
you.
being with me
Thank
today.
you.
Take care.
Have a great
Bye.
one.
Bye.